Hello, my name is Philippe Ballet and I am the head of the Internet Department Advice at the Alain Bensoussan law firm. I am very pleased to be giving this conference on Internet law. The objectives of this course is to provide you with basic knowledge regarding the regulation of the Internet. The challenge the regulator is facing is to address this fast-moving technology and its related services, such as Web 2.0, where the Internet has no frontiers. In this course, we'll focus on applicable law to the Internet. This course is divided in 4 chapters as follows. Chapter 1 covers principle and general remarks. Chapter 2 deals with conflict of jurisdiction. Chapter 3 relates to conflict of laws. And Chapter 4 looks to alternative dispute resolution. Even prior to the very first French regulation regarding the Internet, that is to say the August 1st, 2000 Act, a couple of case law provide evidence that the Internet was not and is still not lawless. One of the very first litigation relating to music, where the court applied copyright to creation broadcasted on the Internet without the consent of their authors. However, difficulties arose when the servers were based outside France and, in the Yahoo case law, in the US, the French court ordered on May 2000 a US company to ensure that French nationals shall not access through an engine search based in the US, material against French law. However, the US judge refused to provide with exequatur necessary for the enforcement of any foreign judgment in a ruling where the French order was held as being against the First Amendment of the US Constitution. Later on, the French judges ordered, in a similar case, all French Internet providers to filter access to non-French-based servers hosting illegal content as to ensure compliance with French law without having the need to seek exequatur in the country of the hosting service provider. The Yahoo case law illustrates how difficult it is to ensure effectiveness of a national regulation with the Internet due to the inner characteristic of that worldwide network and to the lack of harmonized rules. For the regulator, the Internet belongs to public communication, that is to say, one-to-many, as opposed to private communication, that is to say, one-to-one. To be more specific, the Internet belongs to online public communication, whereby an individual is the originator of the above-mentioned one-to-many communication, even though the technical means are provided by a third party, such as an Internet provider. Any signal, from text to voice, is subject to this definition of the Internet. From a technological standpoint, this definition is rather neutral. The very first regulation of the Internet was introduced in France by an act as of August 1st, 2000. This act amended the French Act on Freedom of Communication, dated September 30, 1986. This act defines the Internet as public communication as opposed to private correspondence. Since the August 1st, 2000 Act, where the Internet belongs to public communication, it is no longer compulsory to file a declaration before the Procureur de la République, as for any other public communication service, such as radio or TV services. Also, the August 1st, 2000 Act compels any author of an online public communication service, for instance a website, to identify himself. Consequently, if the provision of an online public communication service is free, its authors may be liable as per French law, for instance regarding defamation. Lastly, the August 1st, 2000 Act introduced a specific liability regime for those who provide technical services such as Internet and hosting providers. Contrary to the general liability regime tort, these technical providers could not be held liable for the contents they store in their servers or transport over the networks unless there is evidence that they were actually aware of such illegal content and had not reacted to avoid this illegal content to be available on the Internet thanks to the technical means they provided for. Well, this is an old story because these provisions regarding identification of users was firstly settled in the Act of August 1st, 2000. And since that date, we can get the same provisions into the law for confidence in the digital economy. However, whereas hosting providers and internet service providers have the obligation to keep data regarding identification of their customers, we are still expecting for the decree which shall specify the kind of data and the retention period for that data. However, this is crystal clear that there is no general obligation for an ISP or hosting service provider to supervise or monitor the service they provide to end users. As previously mentioned regarding the Yahoo case law, there was a strong need for harmonized regulation for the Internet. Moreover, member state domestic initiatives were likely to constitute an obstacle against the free provision of Internet services in the EU. Consequently, the EC adopted on June 8, 2000 the EC Directive on Electronic Commerce in order to set forth harmonized rules for the Internet in the EU. First of all, this EC Directive on Electronic Commerce provides that domestic laws apply to providers being established in the given country. Secondly to this EC Directive sets forth a specific liability regime for Internet service providers such as hosting providers, access providers, but not engine search providers. As per the mere conduit principle, Internet access providers cannot be held liable for any illegal content they may carry over the networks unless they do so under very specific circumstances, for instance, selection of content and recipients. Also, caching service providers benefit from the above-mentioned mere conduit principle. Regarding hosting service providers, they shall not be held liable for any illegal content unless they were actually aware of that illegal content through a formal notice, and further to this formal notice, do not take it down. On June 21, 2004, the French Parliament enacted the Law for Confidence in the Digital Economy as a transposition in the French law of the above-mentioned EC Directive on Electronic Commerce. Besides the rules, as set forth in the EC Directive on Electronic Commerce, the Law for Confidence in the Digital Economy contains some specific requirements which are subject to criminal prosecution. These requirements oblige any website editor of an electronic communication to the public to identify himself, to provide the name of the publishing director who is liable vis-à-vis third parties in case of defamation, for instance, as well as the name of the hosting provider. Failing to do so is subject to 1 year imprisonment and a 75,000 euro fine. As a result, when an editor of a website also provides electronic commerce services, being widely defined so that not limited to the selling of goods or services, but also engine search, hosting services, etc., which is often the case. Such an identification should cover either the above-mentioned editor, but also its place of business. As for any other regulations, the key principle remains the freedom to provide Internet services, as well as freedom of electronic communication, subject to identification of the authors of any content being made available on the Internet. Consequently, whilst Internet service provider benefits from an exemption liability regime for transport on or hosting services, they should ensure proper identification of their own customer, so that in case of alleged illegal content, the latter may be subject to prosecution once identified. However, it has to be noticed that the decree which shall specify the identification data and its retention period is still not being published. This decree has been expected since the August 1st, 2000 Act. The answer is yes. As per the US legislation, the law for confidence in the digital economy has introduced into the French regulation a provision under which any third party may send to a thing provider, for instance, a notification, a formal notification, which has to comply with specific requirements as set forth in the law for the confidence in digital economy, so that the hosting provider may decide to take it down.